Hi, everyone, and welcome to webinar 3 of the Wealth Matters webinar series. Today's webinar will be covering topics around estate planning and intergenerational wealth planning. Dealing with the complexities of wills and trusts can be very daunting, particularly if you have assets in more than one jurisdiction. We will also talk about some of the top mistakes that high net worth individuals make and what we can do to avoid those. The discussion will take on the format of a Q&A session, and I have two specialists joining us today who will be answering some of the questions relating to our topics. So our first specialist is Yariva Ramdhani, and she is currently employed as a financial planning solution specialist at Old Mutual Wealth. And our second specialist is Mandy Dix-Peek, and she is currently employed as the head of Old Mutual Wealth Fiduciary Services. I think it's time for us to get straight into our discussion. And my first question is for you, Mandy. Assuming I die today, leaving behind no will, or I leave behind an outdated or invalid will, what would be the implications of this?
Hi everyone. Hi Ahmalia. Thanks for having us. Okay, if you die without a will, in terms of South African law, you are deemed to die interstate, and the devolution of your estate is then governed by the laws of interstate succession. So there's a specific act that deals with exactly how your estate would devolve. And you have no choice, absolutely no choice. So dying without a will or dying with a will that's invalid puts you straight into the regulations that are governed by this particular piece of legislation. And just to simplify it, basically, if you're married and you have 3 children, your estate is divided into 4. Your wife gets a child's share, which would be 1/4 of the estate, and your 3 children would get the other 3/4, basically. So you have absolutely no choice. So this is a very good reason why you should ensure that your will, you do have a will. Firstly, it is valid. Secondly, and that you make sure that it is updated regularly depending on changes of circumstances in your life. So yeah, first thing, have a will. Second thing, make sure that it's valid and review it regularly to make sure that it changes according to your circumstances.
Sure. Thank you, Mandy. Thank you for answering that for us. And I think it sounds a bit more complex if you would die without a will than having one that is valid. Because then you also ensure that all of your wishes are fulfilled.
You have absolutely no control. As I say, it's governed by this piece of legislation. You wouldn't have nominated an executor as you would have in a will. If you had minor children, for example, this is another complexity. There would be no provision for a testamentary trust, which one would normally have in their will if they had minor children. There would be no provision for the nomination of a guardian of your minor children. Any minor children inheriting, their funds would go directly to the Guardian's Fund, which is managed by the Master of the High Court. I don't think that's going to be anybody's preference at this point. So it's a very risky and probably, not to be too brutal, but quite an irresponsible way of dealing with your succession planning. Let's put it like that, a little bit more diplomatically.
Thank you, Mandy, and thank you for clearing that up for us. Mandy, my second question is also for you. I think nowadays we see a lot of people investing funds offshore. And I think there's a bit of confusion sometimes around whether you should only have one will in place or whether you should have more than one will that will cover all of your assets. Can you perhaps give us clarity around that?
Sure. I wish I could give you a black and white answer, but unfortunately, it is very complex because a South African executor doesn't have authority in every single country in the world to deal with a deceased who has assets in those various jurisdictions. Although some countries do recognize our letters of executorship and will act on our instructions, there are other countries, for example, like the UK, for example, if you owned an immovable property in the UK or an immovable property in the US, you have to go through what they call a probate application in the UK, and a similar application in the US, which basically means that you apply for our South African letters of executorship to be recognized in that country, to enable you as the South African executor to deal with the assets that sit in that offshore jurisdiction. So yeah, the US UK one is quite easy, because I mean I can say for certain that our letters of executorship are not recognized without this particular formal application. We still need to employ or engage someone in those jurisdictions to assist us, in that foreign jurisdiction, to go through the process of administering the estate, the UK estate or the US estate. So it's a difficult question to answer, as I say, because certain jurisdictions they do recognize our letters of executorship and will take instructions without any other formalities. But then there are others that don't. There are certain jurisdictions, particularly in Europe, where European countries don't have what we have in South Africa. We call freedom of testation, where a testator is entitled to leave whatever he wants to whomever he wants. So there are no regulations or laws that govern the devolution of his or her estate. For example, in Austria, there's no freedom of testation, and your parents are entitled to a percentage of your estate. Sometimes your brothers and sisters are entitled to a percentage of your estate, besides your wife and your children. So you need to be very careful that every single situation with all the different variable circumstances is taken into account when you decide to either execute a will in South Africa that deals with your worldwide assets, or you decide that you have a will in South Africa that deals only with your South African assets, and then you do wills in the various jurisdictions in which those foreign assets are situated. So, as I say, no black and white answer, unfortunately. But when you have assets offshore or you have foreign assets in different jurisdictions, I strongly recommend that you consult with a professional to ascertain whether it is necessary to have more than one will, or whether your South African will governing your worldwide assets will be sufficient. I can go into more detail. With regards to things like citus tax, for example, in the UK, if you have an estate, a UK estate that's worth more than £325,000, the estate duty goes up to 40%. In South Africa, we have estate duty of 20 or 25%, depending on the value of your estate. In America, the estate duty or the citus tax is also 40%. And the executor's obligation is to settle the foreign tax authorities and then claim a credit from SARS in South Africa. So that's also another complication, and that can be taken into account when you decide as to whether it's necessary to have a will in that foreign jurisdiction or not, or just to rely on your South African will that governs your worldwide assets. So very complex, very topical, as you say, because more and more South Africans are moving assets offshore. So yes, as I'm going to reiterate, I think in those situations to consult with a professional is probably the best solution. I hope that answers the question. Yeah.
Yes, it does. Thank you. And thank you for trying to make it as practical as possible, given the complexity of it. I appreciate that. I think, Mandy, I'm not sure if you want to take a sip of water, because the next question is also for you. So, Mandy, why does it take so long to wind up in a state? And what can I do as an individual while I am alive to try and make things easier for my family and kind of try and help to expedite the process of winding up in a state once I pass?
Okay, so this is my favorite topic, so I have to talk a little bit longer. Disclosure and transparency are huge for me. So I think the days where wills were secret documents that were drafted without the knowledge of your spouse and your family, and nobody knew what was going to be contained in that will until you had passed away, and someone had found it either under your bed or in a cupboard, or I don't know, in the back of your shoe cupboard. I'm not 100% sure where everyone hid their wills in those days. I have a sort of a particular or a personal kind of crusade about this. I feel that it's more beneficial to be open and transparent with your family as to what you intend to do with your assets, or what you intend happen to your assets after you have passed away. Because I can't tell you the conflict that can arise amongst amongst family members, where the will contains something that they absolutely didn't envisage coming, and that doesn't make for a very happy dynamic, as I say. And it also makes it extremely difficult for an executor. You end up playing psychologist more than anything else, more than a professional executor. You end up trying to manage family dynamics of some very unhappy families. Or family members, should I say. So that's the one thing, disclosure and transparency. The other thing that a lot of people haven't or didn't take advantage of, and that also complicates and delays estates by, can be up to 5 years sometimes, is, have you disclosed your foreign assets? Did you take advantage of amnesty in the early 2000s, in 2003 and 2004? Were they disclosed, or is the executor going to get a surprise and suddenly find out that you've got a bank account in the US, or a property in Italy or Portugal that was never disclosed to either the person who drafted your will or the nominated executor, or even some of your family members? That causes massive problems, because then you get involved in applications to revenue and the Reserve Bank, where it's called the voluntary disclosure program. And in the last couple of years, those programs or processes or applications have been taking 3 to 5 years to finalize. So as I say, disclosure and transparency. Depending on what's in your will, disclose that to your family. If you've got foreign assets, make sure that they're disclosed to the relevant authorities. You're not going to get away with hiding them anymore. With common reporting standards, the automatic exchange of information regulations. There are just so many laws and regulations that allow the flow of information amongst different jurisdictions to enable people to be hiding and not disclosing and not being transparent about foreign assets. The other issue that also delays estates is not being up to date with your taxes. Please make sure that you submit your complete and submit your tax return every year. The poor executor suddenly is dealing with an estate where the deceased hasn't submitted a return for 5 or 10 years because he or she thought maybe it wasn't necessary. So that's another delay, and that can take a couple of take a considerable amount of time to get that all sorted through SARS. Obviously in the last, sort of 12 to 18 months with COVID, we've had numerous problems with the master's office. So that can also cause delays, but that's kind of outside of the executor's hands or the estate or the deceased's hands, obviously, because, if there's a COVID case in the master's office, it closes for a day, and the next day it's closed to be decontaminated. So those are just, small things that have also sort of changed the length of time that it used to take to administer an estate. When I first started doing estates, we could get an estate finalized between sort of 9 to 12 months. This last estate that I've just finalized took 4 years to finalize, and it wasn't a complex estate, and there were no issues regarding outstanding tax returns or undisclosed foreign assets. It just was delay after delay after delay. So make sure your executor knows where your will is, your family knows where your will is, and it's such a great idea to have a file where all your assets and liabilities, the up-to-date statement is is put into a file. Somebody knows who it is. It can be handed over to the executor when it comes to filling in the preliminary inventory. When you report to the estate to the master's office, all the information is there. So as I say, disclosure and transparency is a huge thing when it comes to the administration of estates, and is obviously the one thing that is going to prevent these horrible delays that we're all experiencing. Because at the end of the day, the people that really suffer are your family members, and that's not, I'm sure, what the testator or the deceased envisaged at the end of the day. So yeah, those are just a couple of things that can help prevent delays in the administration of an estate.
Oh, thank you so much again, Mandy. And
Okay.
I think there's a lot of good advice and tips for all of us in what was just discussed. So I thank you for that. I think you can take a bit of a rest because my next
Thank
question
you.
is for Yariva. So, Yariva, my question to you is, what is sudden wealth and why is the concept of sudden wealth such a problem?
Hi, Akmalia. Hi, everyone, and thank you for having us. Yeah, Akmalia, I think sudden wealth syndrome or sudden wealth, it speaks to the heirs or people who come into money suddenly, such as your lottery winners, your jackpot winners, etc., who tend to blow this windfall within a very short space of time. I mean, many people in this situation are overwhelmed and they struggle to deal with the aftershock of such an event, of suddenly receiving a vast amount of money. And honestly, sometimes they don't know where to start. I think the psychology of this shows that how money is transferred to beneficiaries without meaningful purpose can spark really unhealthy relationships with money. And more often than not, it tends to promote a sense of entitlement in some cases. And it's hard to imagine, but sudden windfalls can lead to people feeling as if they don't have to worry about money going forward, as if everything's just going to be okay. I don't have to worry about money again. And it's the same lack of concern that leads to splurging on cars, on holidays, on gifting friends and family, just really splurging and spending money wherever they can before thinking about the future. So that's really what sudden wealth syndrome is about. It's not being equipped to handle the money that's coming your way.
Awesome. Thank you. Thank you for that explanation, Ariba. I think while you were talking, I was wishing that I could suffer from sudden wealth syndrome.
I know.
Yeah, Riva, thank you. My next question is also for you. In a paper that you recently wrote, you spoke about the loss of inherited wealth, which is obviously a huge problem in our society today. So, is there anything we can do to help teach our heirs about wealth preservation and even wealth creation?
Absolutely, Akmalia. And I think we can start with wealth preservation if we look at that. And when it comes to inherited wealth and preservation, one of the key items is communication. And as Mandy, mentioned earlier, it's about being very honest and open and disclosing everything. It refers to preservation of wealth as well. I mean, if you have a family business, for instance, that's going to pass from one generation to another, you have to have some kind of a roadmap or a charter, a family charter in place that discusses pertinent issues of the business, that looks into the expectations of the future of the business. And you have to include the main stakeholders in these conversations, like the lawyers, the trustees, and the accountants, to make sure everyone is on board. And you've got to have some kind of clear handover or succession process in place. Because it's not just about handing over the reins, but you're also handing over the experience, the expertise, as well as the moral and ethical values that need to be passed on from one business owner to the next, if it's, as I say, if it's a family business. And it's just not about businesses only. If there isn't a business involved, but let's just say it's just a transfer of family wealth, for instance, it's still about communication. It's still about talking to each other, engaging with trustees when necessary, having a solid estate plan to make sure that your will is a true indication of your desires, as again, as Mandy mentioned earlier. And really, it's about having honest, open conversations about money. I think too often we shy away from these conversations. It's almost taboo to talk about money. But you need to involve beneficiaries in decision making processes. Allow them earlier on so they know what to expect. And again, so the will's not a big surprise or a shock. So it also builds trust and responsibility, with the beneficiaries and heirs. And I think when it comes to wealth creation, there's no recipe to build wealth quickly. That is definitely a journey. And more often than not, it takes time, it takes planning and making responsible financial decisions and sticking to them. I think wealth creation starts really with a goal. It's about having conversation around what wealth means to you, because wealth can really mean different things to different people. And the best way is to partner with a financial planner who can help you establish a healthy financial habit and build a plan together to start your personal wealth creation journey.
Awesome. Thank you. Thank you so much, Yariva, for answering that for us.
Thanks, Akmal.
Um, my next one, Mandy, is again for you. And it's about the importance of outsourcing the drafting as well as the administration of a will to a professional. What makes that so important, Mandy?
Um, I've so let's start from the beginning. I've seen wills, and actually, I was asked by my husband to look at one of his friends' wills today, and I looked at it and I thought, oh my word, where did this come from? I mean, I think he might have drafted it himself. They are just basic things that unless you have had experience in drafting of wills, you probably have absolutely no idea. Things like, exempting the executor from providing security to the master of the High Court. If that clause isn't in your will, your poor executor has to run around and try and find an insurance company that's going to issue a policy that's going to ensure the value of the estate.
Yeah.
Extremely expensive, and these insurance companies don't do this very easily. So very, very simple example. I mentioned things like making sure there's a guardianship clause. Have you nominated a guardian in your will? Have you made provision for a testamentary trust for minor beneficiaries? That was another thing that I mentioned. If you don't, and you and your surviving spouse have passed away, that money will go to the master's office. And as I say, currently the master's office, not to be too critical, is experiencing huge delays because of the circumstances that we're living under at the moment. So can't stress enough. I mean, in my view, a will is probably one of the most important documents that you will sign in your life. So I mean, Yariva has had some brilliant pointers regarding financial planning, and I'm so glad she agrees with me with the openness and the honesty and the transparency and the disclosure. And you know what? It's absolutely fantastic to have a financial plan, have a relationship with a financial planner. But if you don't have a will and you've got this brilliant financial plan, what happens to all the hard work that you've put into accumulating this wealth if you don't have a document that actually sets out what you want to happen? And I mean, even things like, just to change the subject slightly, a shareholders agreement where there's a business with different shareholders, is that in place? Because if it's not, you're going to have massive problems when it comes to your death or one of your co-shareholders' deaths as to how do you value the shares in the company. If there's no shareholders agreement, there's probably no method set out as to how those shares are valued. So I can't stress enough the importance of while everybody thinks a will is a simple document, either undersigned, leave the rest and residue of my estate to my surviving spouse. Signed. No, it has to be signed in the presence of two witnesses. Otherwise, it's invalid. The witnesses cannot be related to the person who's signing the will. I mean, it's all these tiny little things that unless that you've had the experience of drafting a number of wills over a number of years to deal with all the different circumstances, you're going to find yourself in a huge amount of difficulty. And then similarly, your nominated executor needs to be a professional executor. Yes, nominate your surviving spouse or your oldest son or daughter along with a professional executor. So, and this is one of my recommendations and preferences. I like working with a family member because he or she normally knows the family dynamic. So they'll deal with that part of the estate and I'll take over the work part, the actual administration, the the professional executor will make sure that it's done according to the letter of the law, etc. So I don't think you have a choice. And we can go back to another reason why estates are delayed, because there's a problem with the will, might be invalid. If it is invalid, the only way to have it validated or not, or you are declared that you died interstate, is to make an application to the High Court. Who wants to do that? So then suddenly attorneys, advocates, costs, etc. So the cost of employing a professional to draft your will and make sure that it's done properly, and appointing a professional executor, I don't think you have a choice. Otherwise, you're not there, okay, great, but not so great for your family, because they're the ones that are dealing with the fallout. So yeah, I can't stress it enough. It's such an important document, and something that people just, I don't know, delay and delay and delay and avoid for as long as possible. And it's really not a difficult document if you know exactly what your wishes and your intentions are. So yeah, I can't stress that enough.
Thank you so much, Mandy. And I think thank you for once again stressing the importance of firstly having a valid will in place, and then having it done by a professional, as well as getting a professional to be the executor of your estate. I think those are some of the important takeouts from me,
Very,
especially
very
from that
key.
question.
Yeah.
Yeah. Mandy, thanks. The next one is for you again.
Okay.
Yeah. So, Mandy, what are the benefits of having a trust in place? And when should I, as an individual, think about implementing a trust for myself?
Traditionally, a trust has always been an estate planning tool, because assets that are either, funds are either loaned to the trust by the founder or the donor. The trust then purchases assets with the funds that have been introduced into the trust by the lender or the donor. And say, for example, the donor loans 100,000 rand or donates 100,000 rand to the trust. The trust then buys assets. Let's just say invests in a listed share portfolio. In 20 years' time, that 100,000 rand is worth 10 million rand. Let's just be positive about the markets. And the benefit is that the difference between the 100,000 rand that was loaned, which would be an asset in the lender's estate, and the 10 million rand share portfolio that is sitting in the trust, is that the 10 million rand less than the 100,000 rand is not subject to estate duty, because it is no longer in the individual's name. So from an estate planning point of view, that is a massive benefit. This has been sort of a little bit negated by the introduction of Section 7C of the Income Tax Act, where previously loans to trusts by individuals were accepted by SARS if they were interest-free. This changed with the introduction of Section 7C, and you are obliged to charge interest if you make a loan to a trust that's over 100,000 rand. And the 100,000 rand, not over 100,000 rand. The 100,000 rand would be a donation and be donations tax-free. But the interest that you should have charged the trust and haven't is deemed to be a donation to the trust, and you pay donations tax on that interest. So there's been a little bit of negativity around trusts in Section 7C, but they certainly do still have great estate planning benefits. Another huge benefit of trusts is, for example, setting up a trust for somebody who is, let's just say, for example, you have a minor child who may be physically or mentally challenged in some way. One way of them of their assets being looked after is to ensure that they are accumulated within a trust and looked after by professional trustees and professional financial advisors. So that also is a very important benefit of a trust. You need to make sure that the trust is run properly, administered properly, financial statements are drafted every year, tax returns are submitted. So there again, we were talking about professionals drafting wills and administering estates. Very, very important to have a professional trustee, and not just you and your wife, as I don't want to say dummy trustees, it sounds a little bit critical, but because there's a possibility that the courts can look through the trust and say, oh no, well actually you weren't managing those assets in a professional capacity. You were managing them as they were your own, not that they belong to the trust. So that's something that you need to make sure of. Master's now insisting on the appointment of a professional trustee. So you're not going to get away easily with just yourself and your wife managing and acting as the trustee of a trust. So while there are complications, there are still benefits, as I say, estate planning benefits or estate duty saving benefits, assisting with physically and mentally challenged minors or adults for that matter. Often farms are held in trust because they are assets that are passed from generation to generation. So if you held it in your personal capacity, you might be passing it from one individual to another individual, or to two or three individuals or whatever. So a trust is a good vehicle for a farm, for example, for a holiday home that you'd like to keep in your family, for generations to come. So yes, and for different people, there's going to be a right time to set up a trust, and for others it will be a different time. But as I say, you just need to keep in mind the disadvantages of Section 7C, and the reason, the actual objective of setting up the trust is key. It's not always going to be estate duty saving. It's not only always going to be for somebody who has challenges, etc. It's going to be different circumstances will dictate why trust should be set up. So a very complex area, but definitely there are still huge advantages.
Thank you, Mandy. And once again, thank you for the practical pointers and advice again that came out of your answer. I enjoyed that. I think we are almost nearing the end of our discussion, and there's one more question for Yariva. Yariva, so why is it important to think about intergenerational wealth transfer, and how can a financial advisor actually support me with this?
So, Akmalia, I think if we think of intergenerational wealth transfer, we must look at some of the stats that present itself as well. So if you look at the New World Wealth Report from 2020, South Africa is the largest wealth market in Africa, and people living in South Africa together hold about 636 billion US dollars in wealth. And if we look at about 42% of this is held by high in network individuals. It's individuals holding that amount of wealth, and most of them are well over the age of 60. So if we consider that amount of money and the age groups that this money is being held by, we can really see that a massive generational wealth transfer should happen sometime in the not too distant future. The concern is if heirs are not equipped to deal with this transfer of wealth, they can easily miss a once in a lifetime opportunity and spend the money without careful consideration and planning, which is what we spoke about earlier in terms of sudden wealth syndrome. So they need to be equipped with the skills, the knowledge, and support to handle the money that's coming their way, so they're able to deal with it. And it's not just splurged and spent and, there's regrets thereafter. And I think having a financial planner can really assist with this, because engaging with a planner to co-create a plan for this money and pegging goals and aspirations that include the beneficiaries and making plans now is, while you're alive, and involving everyone in the decision-making process, it makes it so much easier when the wealth is transferred. It reduces the risk of this money being squandered. And a financial planner can also, provide advice and guidance and bring in the expertise of other specialists to look at tax efficient structures, to look at what is available to a client that'll help not just with estate planning, but just with, securing this wealth, growing this wealth, preserving it, and really just to create a lasting legacy for future generations.
Thank you so much, Yariva, and thank you, Mandy, as well, for being here today,
Pleasure.
for making the time to help us work through these questions. Because I think um, nowadays, a lot, like I said, a lot of high net worth individuals even make these kind of mistakes. And I think it's important to have these open discussions where we can actually learn from the experts in the field about many of these topics. And I certainly found value out of today's session. And I'm sure that our audience also found a lot of value in what was delivered here today. Thank you so much for joining us and have a good week further. Thank you.
Thanks, Akmalia.
Thank you. Thank you.
Thank you.